We're now going to put the spotlight on one of the most bitter corporate battles. I'm talking about Tata versus Mistry. It's been a couple of days since we saw the sensational headline of the NCLAT, that is an NCLAT, calling the removal of Cyrus Mistry as illegal and reinstating him as the executive chairman. The question today we are asking on India Development Debate is, how big a win is it for Cyrus Mistry? A deep dive into the verdict, and this is what comes up. Yes, he has been reinstated as executive chairman of Tata Sons, but we at ET now learn Cyrus Mistry is no longer interested in being the executive chairman of Tata Sons. A lot of what Cyrus Mistry had asked for has not been granted by the NCLAT. So is it indeed a big victory for Cyrus Mistry? For example, his big contention was he and the SP group must have corresponding representation on the board for being one of the largest shareholders with an 18% stake. That did not happen. In fact, if you look at the NCLAT judgment, Cyrus Mistry can be a director for the balance, the remaining part of his tenure. That means 5 months. Best case scenario for Cyrus Mistry, 5 months of directorship. The verdict is silence when it comes to nominee directorship. So on today on India Development Debate, this is exactly what we are going to be discussing. Remember, it's one of the most bitter corporate battles we've seen in a long time, perhaps the most bitter one since the fallout of the Ambani brothers. Joining me on India Development Debate now, Mohit, Saraf, senior partner at Luthra LNL, and we're also being joined by Sanjay, the senior partner at Crawford, Bayley & Co. Gentlemen, thank you for joining us this Christmas Eve on ET Now on the India Development Debate. You just heard me talk about the story that we picked up. Cyrus Mistry not interested in the executive chairmanship at Tata Sons. In fact, we understand from our sources that the two warring camps have not even spoken to each other. There has been zero contact between the Mistry camp and the Tata camp since the verdict of the NCLAT. Cyrus Mistry, best case scenario for himself, gets directorship for just 5 months. And I'm going to get into this argument, this question also with both of you gentlemen, renowned lawyers that we have, legal eagles, on whether the courts should be entering this. Is it the jurisdiction of the court? That's a separate discussion we're going to be having. But Sanjay, where do you stand? Do you think it really has been a big win for Cyrus Mistry? And what will be the ramification of this order then on India Inc.? The largest shareholder doesn't get guaranteed nominee directorship or even directorship.
I would say that the corporate democracy, the majority rule prevails. Now, there are two things. One is removal of a director from the board of the company. And the second one is operation or operative acts on the minority shareholder. As far as the first question is concerned, on the removal of director, to my mind, the law is quite settled that a director can certainly be removed by the majority votes of the shareholders. Now, to my mind, the court did not go into the facts as to whether the director is being removed with mala fide intention or otherwise. It's absolutely the prerogative of the shareholder to appoint a director and to remove a director. So if there is a majority votes of the shareholders for the purpose of appointment of director or removal of a director, then the shareholders wish, the shareholders will prevail. However, in this case, it's coupled with the point of operation of the minority shareholder, and the tribunal or the NCLAT have gone on the facts of the case to say that because the actions of the majority shareholders were so very oppressive and they were not justified in removing Mr. Mistry as the shareholder, as the director or the chairman of the company. And so is the case in the case of all the operating companies wherever Mr. Cyrus Mistry was a director of the company. So in other words, although the settled law on the matter of removal of a director is that the majority rule shall prevail, however, in this instant case, because of the provisions of 242, which is relating to the operation of the minority shareholder, the tribunal have exercised their discretionary powers on the basis of the facts and circumstances of the case and have come to a decision that look, the acts of the majority shareholder was so very oppressive that they were not justified in removal of Mr. Cyrus Mistry as the director of the company.
Okay, so that sets the stage for this debate. But Mohit, Saraf, if I could now come back to you, and this is a conversation we were having, and I said we would get into it, whether it should be the shareholders' prerogative and all of that. 5 months best case, according to the NCLAT, for Cyrus Mistry to get directorship. I'm going to ask you what I asked Sanjay Asher as well. What do you see this to be as the ramifications, as a precedent for corporate India?
I think this is a very dangerous precedence which we have established for corporate India. Imagine people buy into company 26%, 51%, 75%, because with every position of equity ownership, they get certain rights. So really what they understand is that if you get into a 51% or a 75% of the company, you get certain rights. And that's really what people want, management control. Now what this judgment is doing is that even if the rights of the minority shareholder is not in the articles, still the courts can actually enforce certain minority right without there being really an oppression and mismanagement. Because really I could not see what was in oppression and mismanagement. If you had a right under law and that right was not exercised or could not be exercised by Cyrus Mistry, clearly that is an oppression and mismanagement issue. But if you don't have a right under law and the courts give you that right under the garb of oppression and mismanagement, I believe it's an oppression and mismanagement actually of the majority, not the minority. Because minority is trying to achieve something which the law does not provide, the articles do not provide. And really calling a business decision as oppression and mismanagement is, I would say, something which is unheard of. And clearly the courts cannot decide whether the nano car project was right or wrong. This is a business decision. And Mr. Mistry was the chairman of the board all this time, and he never questioned it. He only questioned it after he was removed. And please remember, Nayantara, one important issue, that Cyrus Mistry was never appointed as a nominee of a minority shareholder. He was appointed as a nominee of majority. So Tata's sons, as a majority shareholder, appointed him. And Tata's son, as a majority shareholder, has removed him. He never had a right as a minority. So I cannot understand and fathom where is the oppression. Wherever you can see, it was really an oppression by minority against majority, because it's against the majority rule.
We never hear of oppression by the minority against the majority, right? So, I mean, I'm still thinking that in what you're saying, Mohit Saraf. But Sanjay Asher, do you agree there with Mohit Saraf? You made it clear that it may not and should not be how the business is conducted and how boardrooms are conducted necessarily be decided in the courts. It comes under the company's law. It's under the purview also of the shareholders. But I'm going to come back to you with this question as well. Now that we've had time to digest the headline and we understand that Cyrus Mistry is not even interested in being the executive chairmanship, he really hasn't got a lot of the press that he was seeking, whether it was to do with the Tata Trust veto vote, whether it is to do also with what they would have ideally wanted with the possible defamation, and of course the board seat.
No, I would say that, as Mohit explained, that you have 51% of the shareholding in a company and a 75% of the shareholding in a company. In order to appoint directors and to remove directors, when you opt for 51%, you would want to see that the directors or the majority of directors are appointed by the 51% shareholder and they're removed by the 51% shareholder. Also, if Cyrus Mistry was nominated by the Tata Trust as its nominee for the purposes of its representative on the board of directors, obviously they were justified in his removal as well with the majority shareholding which they had. And so therefore, it has far-reaching repercussions and ramifications on corporate India. Then what is the point of having 51%? Your 51% shareholding goes by the wayside. If you cannot exercise the rights as a 51% shareholder, then why the hell do you require 51% shareholder? What is the importance of that 51% shareholder? You are snatching away the legal right which has been given by law to you for the appointment of majority directors and removal of the majority directors under the garb of oppression. If there are any actions of oppression, then one has to point that out. Now here, because there were bad business decisions or the business decisions in hindsight look bad, that would not mean that there were oppressive acts which were conducted or which were committed. And therefore I would say that this particular judgment of NCLAT would have far-reaching.
Let me interrupt there. When you say there's going to be huge ramifications, when you say this is going to have huge ramifications and you question the fact that you've got laws that protect that 51% shareholders and what you get with it, and what is the point then of having that, what are these ramifications you're talking about? Can you explain to the viewers of ET now what we're talking about? Because that is the point of this discussion as well. It's not just about Cyrus Mistry versus Ratan Tata. This verdict is going to have a cascading impact.
Absolutely, I'm on that point. I'm saying that if I'm having 51% shareholding in a company, I should be able to exercise my rights freely. I should be able to remove the directors and I should be able to appoint all the directors. Otherwise, why the hell should I keep 51% shareholding? The law has given me that particular right. The tribunal cannot snatch away the rights which I have. The law, to my mind, is quite settled that a 51% shareholder can appoint all the directors and can remove all the directors.
Mohit, come in there. For the sake of that 51%, that doesn't mean it has to be at the cost or the expense of another large shareholder. 18% is a lot.
Nayantara, I think again, this question you are raising is more as a moral right. Sanjay and I are talking about the legal right. The legal right is if you are a 10% and above shareholder, you have a cause of action for oppression and mismanagement. You have a right to have a nominee on the board, provided that is reflected in the articles. Now, unfortunately, when Cyrus family invested in the company, they did not ask for that right. If they did not ask for the right, in hindsight, they cannot ask for the right. This is the same Indigo fight that the two partners agreed they did not have one certain right, and later on Mr. Gangwal wanted the right which he did not have. Same issue is here. So it is not a question which we should look at is whether it is fair or unfair. We should look at it, is it in accordance with law, or somebody is trying to exercise certain right which he does not have under law and he does not have under article. So this is not a question of fairness. And I think the same question the court had looked into fairness by disregarding law. And fairness has no concept under common law, because these are commercial contract. If you did not negotiate, you cannot get it.
Yeah. So, okay. I like that parallel between that you've drawn with Indigo. But Sanjay, Asher, if I could now come back to you, I can. The question I want to now ask you also is that, and this is something that we talked about, both of you talked about in your first answer, which was about the conversion of that public to private and what the NCLAT has had to say, and how that might make it more difficult for Cyrus Mistry to be squeezed out. My question is that, is it even possible practically to squeeze out Cyrus Mistry, simply because look at the number of zeros, the kind of bucks that would be required to even buy him out. Even in the original contract, there are so many ifs and buts, and it has to be a rare instance. We're talking about one of India's largest business houses. The fight is clearly far from over. There's zero contact between the two camps. Of course, it'll go to Supreme Court, but the question is that if you have a person who doesn't want to be squeezed out, and you don't want to buy him out, how can it naturally end?
No, okay, I'll answer that question. Let me first complete the point on the 18% shareholder having a right to appoint a director. The law does provide what is known as the system of proportional representation. If you are a minority shareholder, the day you become a shareholder as a minority shareholder in the company, you negotiate your right that the directors will be elected or will be appointed by the system of proportional representation. There is no provision in the articles which says that the directors shall be elected or appointed by the system of proportional representation. Now, as an 18% shareholder, the Mistry group could have negotiated the day they became a minority shareholder that let the directors be appointed by the system of proportional representation, in which event the majority shareholder can no way remove the proportionate number of directors appointed by the minority shareholder. Now coming back to your question of conversion of a public company into a private company. Again, by converting the public company into a private company, there is nothing on the minority which has affected the minority shareholder. It affects the entire bunch of the 100% shareholder. It is the shareholder's prerogative to decide whether you want to continue the company as a public company, or you want to convert the company into a private company. The law permits you to to convert the company from a public company into a private company, and it is both beneficial and disadvantageous to all the shareholders and not only to the minority shareholder. So what is wrong if the Tata Group has converted the company from a public company into a private company, and thereafter if the next consequence of that is to provide the restriction on the transfer of shares and the manner in which the valuation of the shares has to be done, or the way the shares have to be transferred to the existing shareholders, or to squeeze out the shareholders in a company, it applies equally applies equally to all the shareholders of the company and not necessarily only on the Mistry group. So I don't foresee in law, if there is a proposition to convert the company from a public company to a private company, at the end of the day, if at all a shareholder has to be squeezed out, the shareholders has to be squeezed out in a fair and an equitable manner, and the value of the shares have to be done in a fair and a transparent manner.
Okay. I take your point. I take both you gentlemen's points over here. So this was a deep dive into the verdict. It's just one of the many conversations that we'll be having on India Development Debate and on ET Now, one of the most bitter corporate battles that we have seen in recent times. Mohit, of course, brought up Indigo. This is perhaps the most bitter one after the Ambani brothers, with huge ramifications on Indian business and, of course, the corporate landscape. Gentlemen, thank you for joining us here on India Development Debate, and here's wishing both of you and your families a Merry Christmas and a Happy New Year. And with that, we're going to take a short commercial break. But before we go into that, in case you missed it, here's a very interesting tweet put out by none other than Anand Mahindra, where he's talking about his college mate Bill Gates and how it is that the Mahindras got a meeting when it came to Microsoft. We'll take a short commercial break and we'll be back.